Tully Rinckey PLLC thanks the Blacks in Government Executive Committee for allowing the firm to present this free webinar to Blacks in Government members. The firm supports the goals and objectives of Blacks in Government, and we're pleased to be of service to you. Through our partnership, Blacks in Government members are entitled to 2 free half-hour phone consults per year regarding federal employment, security clearance, or military matters. Members pursuing claims receive a 10% discount on legal fees. Call us at 1-888-529-4543 or email info@fedattorney.com to learn more about our partnership with Blacks in Government and schedule your free consultation. Tully Rinckey PLLC partner Rachel S. Young Esquire provides representation to federal employees in a wide range of employment and labor matters, including claims of age, gender, race, national origin and color discrimination, sexual harassment, wrongful discharge, and retaliation. Ms. Young has practiced frequently before federal, state, and District of Columbia courts, in addition to representing clients before the Equal Employment Opportunity Commission, the D.C. Office of Human Rights, and other state and local administrative bodies. Tully Rinckey PLLC is one of the nation's largest federal sector labor and employment and military law firms. We're a full-service firm for federal and government employees with legal issues. Our attorneys together have about 130 years of experience practicing federal employment law. They're key components of a team whose targeted, aggressive legal approach has secured positive results for clients in virtually every aspect of federal employment and labor law. Don't leave the future of your federal career to chance. Call 1-888-529-4543 or email info@fedattorney.com to schedule your free consultation with a member of our team. Now, I'll turn the floor over to Rachel S. Young, Esquire.
Thank you, Stephen, for that introduction. As indicated, I'm Rachel Young. I'm a partner with the law firm of Tully Rinckey, and I will be speaking to you today on the topic of 2 methods of defending your federal employment rights. And we'll center on mixed case appeals versus mixed case complaints. This is a particularly challenging area of the law as it involves the intersection of the jurisdiction and laws of 2 different agencies. So I look forward to being able today to provide you with guidance as to navigating one of the more complicated processes involved in asserting these types of claims. To begin our discussion, I'd like to center on the topic of what exactly I'm talking about. What is a mixed case complaint or a mixed case appeal? Essentially, as I mentioned, we're talking about claims that involve the interface or the overlap of 2 different agencies, and those are the U.S. Equal Employment Opportunity Commission that has the responsibility of enforcing discrimination claims, as well as the U.S. Merit Systems Protection Board, which in its appellate jurisdiction has the ability to oversee certain types of disciplinary action or adverse actions, as we call them. So the types of cases we'll be talking about today involve mixed case complaints and mixed case appeals, which involve situations where an action that has been taken by your manager gives rise to an appeal to the board, such as a demotion or reduction in grade and pay, or removal, as examples, and the employee is asserting that the reason for that action is unlawful, I should say, is based on their protected status under bases that are deemed appropriate for jurisdiction pursuant to U.S. EEOC, such as race, national origin, color, sex, age discrimination, disability, or genetic information, as well as religion, which is missing from our list, as I know. But to begin our discussion, when we're looking at a complaint that interfaces with these 2 areas of the law, we use the terminology of mixed case complaint to refer to a complaint of discrimination that's been filed through the EEOC or EEO process. So when we're defining a mixed case complaint using that terminology, we're talking about a complaint that goes through the federal agency's standard EEO administrative complaint process. And that would be subject to, of course, the rules and regulations that are promulgated by the U.S. Equal Employment Opportunity Commission. Likewise, when we use the term mixed case appeal, what we're talking about there is a case that can be appealed to the board because it involves an action that falls subject to the board's jurisdiction. And again, we have the intersection of an allegation of discrimination for a covered basis pursuant to EEO law. So now that we've defined exactly what a mixed case complaint and a mixed case appeal means, I want to give you some guidance on how to bring a mixed claim. I'll use that term more generally. Essentially, under the EEO's guidance set forth in its Management Directive, or MD 110, there's a two-part test that we often use to trying to sort out how to bring a claim, where to bring a claim, and what the options are. Because there's a number of different options that are available to you, and we want to sort out what's the best for a particular situation. So under the EEOC's MD 110 test, it's essentially two-pronged. And we look at the first question of, A, whether an employee has standing based on their employment status to bring a mixed claim. That's question one. And once we analyze that for a few minutes, then we'll turn to question two, which is the issue being challenged appealable to the board? Now, it seems like a very simple test, and we'll go through the prongs, but as you will see, there's a lot of exceptions and there are complications to the test. So for right now, I'll give you some guidance generally on answering both of these two questions. First of all, in assessing standing, it's important to understand that only certain employees have the right to appeal to the Merit Systems Protection Board. Everyone does not have that right. So depending on your employment status in the agency you work for, you may or may not have the ability to appeal to the board. I will give you some general rules in terms of who that typically looks like, and that includes competitive service employees who have already completed their probationary or their trial period under initial appointment. If you are a probationary employee, the chances are high, although not complete, but they're high, that you likely do not have standing to file before the board. What we would suggest to you if you are working in a probationary status is to speak with an attorney to analyze your particular situation, your appointment, and the specific facts of your case to evaluate whether as a probationary employee you can kind of get around the general rules. But, you know, from the perspective of analyzing competitive service employees, the general rule is if you are in a probationary status, you will not have appeal rights to the board. So your option begins or remains to go through the EEO administrative process. Another group of employees that generally have the right to appeal to the board include career appointees to the Senior Executive Service, or SES appointees. Non-competitive service preference eligible employees that have at least 1 or more years of current continuous service, such as USPS employees or attorneys with veterans preference, typically also have appeal rights to the board or appealable action. Another category of employees that generally do have appealable rights are those that are non-preference eligible, accepted service employees that have completed their probationary periods or that have 2 or more years of continuous service. Now, if these rules seem somewhat complicated, it's because they are. And, you know, certainly there are a lot of exceptions. And, you know, frankly, a lot of us attorneys here at this firm and probably elsewhere keep our own personal notes handy so that when we have a particular person that comes in, we can review a number of statutes to find out, you know, if you are someone with appeal rights to the board, make sure that we make a proper assessment of standing. But for today's purposes, these are the general rules that give you some guidance in terms of how to make that analysis proper in your specific situation. As indicated, in order to bring a mixed case claim to the Merit Systems Protection Board, you have to have standing. So this is always the first step in the analysis before we move on to the next part of the analysis, which is the question of whether or not the action that has happened to you is an appealable matter. The board has very specific jurisdiction, which is set forth in statute. Outside of that, the board does not have jurisdiction over appeal, so it always looks to a specific statute in order to discern whether or not an appeal may be properly brought in this forum. And that analysis takes place in every case immediately at the Merit Systems Protection Board upon the filing of an appeal. Oftentimes, if you're an employee working in the workplace, there can be all sorts of things that are challenged, ranging from disciplinary actions such as a letter of reprimand or a letter of warning, up into including removal. Now, all of those actions, which are serious in nature always from the perspective of the employee, do not give rise to jurisdiction at the board. Generally, the board hears the more serious matter as defined by statute to include, from a performance perspective, reductions in grade or pay or removals that are based on unacceptable performance pursuant to Chapter 43 of the U.S. Code. In addition to that, removal, reduction in grade or pay, suspensions that are for more than 14 days being the marker there, or furloughs that are for periods of 30 days or less for cause, are also subject to the jurisdiction of the Merit Systems Protection Board. And, you'll see in a number of cases that agencies try to avoid creating MSPB jurisdiction by issuing suspensions to employees that are right at 14 days and preclude the board's jurisdiction. So if you have a suspension that's 14 days or more, demotion, a reduction in grade of pay, or removal, or furlough, those actions tend to be appealable and fall squarely within the jurisdiction of the board, provided that an employee has appropriate standing. Other examples include separations, reduction in grade and pay for more than 30 days, when those actions are undertaken as a result of a RIF or a reduction in force. And there's a couple of other items here that we've outlined to include RIF actions that affect a career appointee in the SES service, as well as reconsideration decisions that sustain a negative determination of competence for a GS, a general schedule employee, as well as the disqualification of an employee or an applicant based on a suitability determination that's been rendered by the agency. So these are the general parameters that deal with appealable matters to the MSPB. So again, once you satisfy this two-step process of seeing if A, you have standing based on your employment status in the agency you work for, and then secondly, based on the actual action that's been taken by the agency against you, we can discern whether or not you have the ability to appeal that matter to the Merit Systems Protection Board. So then moving forward, we're going to operate under the assumption that A, you've checked off both the boxes of standing as well as the box for having an appealable matter. That gives us now, it brings us to the position where we should assess what is the right step for you. And there are options. So let's talk about what those options are. First of all, when you are trying to choose between the EEO process as well as the MSPB process, it's important to understand, number one, that you have the right to notification from the agency of your predicament, so to speak. So the agency is obligated when issuing a decision that is grounds for appeal to the Merit Systems Protection Board. The agency is required to give you notice of those rights so that you don't have to engage in the guessing game of trying to figure out what your rights are. So if you receive, for instance, a notice of proposed reduction in grade and pay and a decision rendering that action effective, if you flip through the action, there should be, absolutely should be, from your agency a definite statement that talks about your right to appeal to the Merit Systems Protection Board. And if the agency fails to provide you with adequate notice of your right to file with the board or an EEO matter, Then under the case law that exists both at the board and at the EEOC, the deadlines that apply are considered told or stayed because of the agency's failure to comply with the law in providing you with adequate notice. That's very, very important. So when you receive, if you are in the unfortunate position of receiving that type of notice, read it through very, very, very carefully, every single line, every sentence, so that you understand fully what your rights are. And in the event that the agency gets it wrong, makes a mistake, whether it's unintentional or deliberate, then understand that there may still be a recourse for you to proceed with processing your rights under these processes. A related principle, because you do have alternatives here in terms of which way to go, it's important to understand that you have the right to make an election of process. And once that election is made, you are sort of pigeonholed into that election. So once the action is issued to you, and to stick with the example that I used before of a reduction in grade and pay, it's important to understand that you have the right to choose whether to begin the EEO process or to go directly to the MSPB to initiate an appeal action. And there's pros and cons, frankly, to both. You cannot make a filing in both forums. So if you do, by mistake or, simply being confused by all the things being thrown at you in this process, and you file both an informal complaint as well as an MSPB appeal, then the rules say that the election is made based on whichever step you use first. So once you've made that decision, it's considered to be irrevocable. It can't be changed, and it's based on where you make that election first in the process. I will note, like pretty much every general rule in the law, there's usually at least one or more exceptions to the rule. And this is one of those instances. Because as I went through the two-step process with you, and you now understand, how complicated it can be sometimes to figure out if you have the right to appeal to the board and if the board has jurisdiction over your case. Sometimes employees make mistakes, not intentional, but trying to navigate the process, sometimes mistakes happen. And an employee believes that the board has jurisdiction over their case, even though they may not. So what typically happens in those situations, an appeal is filed with the board, and then the board will issue what we call a show cause order. And that essentially directs the employee, who's an appellant in that situation, to tell the board why you believe the board has jurisdiction over your claim. So once the administrative judge assigns your case to reveal whether or not the board has jurisdiction, they'll issue an order. And if that order establishes that there is no jurisdiction at the board, you are not essentially backed into a corner pursuant to this election rule. In those limited circumstances where the board issues an order that establishes there is no jurisdiction over your appeal, the agency and the EEOC will still process your claim as a non-mixed case. So then you will have the right, and in fact, the MSPB's order will notify you of your right, and the agency itself must notify you that you still have the right to proceed out of the MSPB process and to contact an EEO counselor to initiate an EEO claim of discrimination in that forum. So this is one of the exceptions that is very favorable to employees to ensure that once you make that choice, if it turns out to be the wrong one based on the lack of jurisdiction, you still have the ability to pursue your claims in the appropriate EEO forum as well. So now that we understand the rights that you have as an employee to notice as well as to make an election, we want to talk about the avenues available to you. I will begin my discussions with option one, as I noted here in the slide, which is the option of bringing forth an EEO complaint. In the context, again, of a mixed case as opposed to a non-mixed case. In a mixed case, One of the options you have once you receive a decision that is appealable to the board, to stick with our example of a reduction in grade of pay, or I'll call it a demotion, you have the ability to initiate an informal EEO complaint. You need to do so within 45 days of the effective date of the action. So if you're dealing with a demotion action, you'll receive a letter of decision. You'll look through that very carefully to see when that action becomes effective. If that action becomes effective, let's say on January 1, then you want to count 45 days from when that action becomes effective in order to evaluate your deadline to initiate an EEO complaint. Now, as someone who's practiced in this area of law for many years, met many people, seen many different situations, I will strongly encourage you, do not wait till day 45. If you've received an action that you feel is discriminatory and you feel that you want to challenge it, don't wait till the last minute. File it timely. You may ultimately win if you have to argue with the agency about timeliness, but it can save yourself a great level of headache. If you file the informal complaint, initiate contact with the EEO counselor well within 45 days of when that effective date is, to avoid that debate, even if you ultimately can win it. Saves you time, heartache, and lots of energy. And I would also encourage you, if you're in a situation where you're initiating this process and you're going to initiate your informal EEO complaint by contacting a counselor, make sure that you document your initiation efforts in writing. So if you need to pick up the phone and call the counselor or walk into the counselor's office to file your complaint, after it's over, get their business card and send them an email that says, I am following up to confirm the discussion that we had today, indicating that I want to file an EEO complaint. Document when you made contact. Again, that's another tip that can save you a lot of time, a lot of energy and heartache by establishing, A, that you contacted the EEO office to initiate the complaint, and B, when you did so. So those are the first couple of steps that you do. Once you've filed an informal EEO complaint, you'll be presented with a couple of options in terms of how you want to proceed, either through the traditional counseling process, which is where the EEO counselor serves as sort of a mediator between you and the agency managers to discuss your claim and the relief that you're seeking. The alternative to that process is to ask for alternative dispute resolution, which is a formal mediation process in which a mediator is appointed if both parties agree to this process to essentially talk and to facilitate discussions between you and the agency in an effort to resolve your complaint. If the informal process is not successful in resolving your case, you will be issued a document that is called a notice of right to file, as we call it here. And it's basically a notice that tells you that you have 15 days from the receipt of that notice to file a formal complaint, just 15 days. So again, to follow the advice that I gave a couple of minutes ago, don't wait until the last minute to file your complaint. Do it well within the 15 days. And then secondly, do it in a way so that you can prove when you mailed the document, when you sent the document, to avoid a timeliness challenge subsequently by the agency as it tries to escape being responsible for your case. So once you do those two steps, so filing the informal complaint, going through that process, and then filing a timely formal EEO complaint with your agency, the agency now has its own deadline for one, which is an 120-day deadline to investigate your complaint and to issue a final decision on the merits of whether or not the agency is liable for discrimination. The agency's obligation is to complete this process in the context of a mixed case complaint just within 120 days. And this is a rule that differs a bit from the non-mixed case process, and it does so to accelerate the process. If you're someone facing a removal action, circumstances are dire. You want to move forward as quickly as possible because the agency adjudicates that complaint. So in this context, the agency needs to complete its investigation and issue a decision within 120 days of when you file that formal EEO complaint. And I'll talk in a little bit about what you do if the agency timely initiates that decision. But in many instances that I see, including one instance that I'm dealing with now for one of my clients, 120 days has come and gone and the agency has failed to conduct a timely investigation. Well, you don't have to sit by and wait forever for the agency to do its job. What you have the ability to do after 120 days are over, if the agency hasn't met its administrative and regulatory obligations, is to then at that time, if you want, you can move forward with filing your appeal with the Merit Systems Protection Board then. If you find yourself in that situation, I'll give you a little tip of the trade in terms of what I do. It happens. So when we file an appeal and the agency has not yet issued its final decision, I include a notice to the judge, a specific letter to the supervisory administrative judge at the board, notifying them of the steps that we have taken to initiate the informal complaint process, when we received the notice of right to sue, when we filed a timely formal EEO complaint, and then I conclude that summary in a bit more detail. But I conclude that summary by advising the senior judge at the board that the agency has failed to comply with its deadline. And that's one of the tools of the trade that you can use to essentially show the MSPB, based on your initial filing, that there is jurisdiction over your appeal. And what you can try to do is to prevent a show cause order being issued by the board as a result of them not understanding if your appeal is timely or not. That's just a tip of the trade for you. If the agency does its job and within 120 days it issues that final decision we were discussing a moment ago, more than likely, and probably at least 95% of the time, the agency will not issue a finding that states its action was discriminatory. It is of no surprise that these agencies are not inclined to issue findings of discrimination against themselves. So generally, and probably 95% of the time, you likely will not receive decisions acknowledging that the agency discriminated against you. But if you do so, then probably I would advise you to contact an attorney, because what we now want to look at is are the appropriate damages to you. But assuming that the typical decision is issued, one that indicates that there has been no discrimination based on the agency's review of the circumstance, you have the ability then at that point in time to do one of two things. Either A, to file an appeal with the Merit Systems Protection Board, or B, to file a lawsuit in federal district court. And the option is yours in terms of which of those steps to take, assuming you want to proceed further with bringing your mixed case complaint. So that, in a nutshell, summarizes option one of going through the process. There's another option that's available to you. If you receive a action, and to use our demotion as an example, you receive a decision indicating that the agency is going to reduce your grade and pay. In lieu of going through the EEO process and initiating the informal complaint and the formal complaint and waiting 120 days for the FAD to be issued, or the final decision to be issued, you can decide to go immediately and directly to the Merit Systems Protection Board to file an appeal that challenges both that demotion action, to use our example, as well as to assert your claims of discrimination. This is a more direct path to the board. And, on its face, it might say, well, why go through the EEO process and, go through all those steps and wait all that time if I can go directly to the board? It's a great question. And I don't have an answer for you here today. In fact, I would never say that one approach is better than the other. I would say to you that it depends on specific circumstances of the employee's circumstance. What the claims are, what their goals are, what their financial resources are, what the timeline looks like. So I can go on and list probably 10 more factors that we consider. But for each person, making the decision as to whether to go with option one versus option two is really a personal decision that should be made upon evaluating a number of factors and deciding what the most appropriate step is for you personally as a result of those considerations. So if you are inclined to go directly to the board, then you skip pretty much most of the steps I was talking about, and you're subject to a different deadline as it relates to filing with the board. So whereas when we were talking under option 1, having 45 days from the date that the action becomes effective, in the context of going directly to the board, it is a shorter time frame. It's only 30 days. Remember it. It should also be written in the written documentation that you receive from the agency as part of the notice requirements that we talked about before. The agency is supposed to not only tell you what your rights are, but to tell you when you have to do certain things in order to submit a timely appeal or a timely EEO complaint. So in the context of option 2, you have 30 days from when the action becomes effective to raise that matter to the MSPB. One of the differences, the key and fundamental differences between going with option 1 through the EEO process and going with option 2, the appeal to the board, deals with the topic of burden of proof. Who has the burden of proving what? And as someone who represents employees primarily in these types of disputes, I can tell you, we'd like to have the agency have the burden of proving their action whenever possible. So one of the pros to bringing a case before the Merit Systems Protection Board is the fact that the agency has the burden of proving the legality of the underlying adverse action that is taken against the employee. So to use our example of a demotion, at the board, the agency is responsible for proving by a preponderance of the evidence its burden of proof. And that burden of proof is set forth as a matter of law under the board's jurisdiction and prior decisions. In conjunction with that, when you're bringing a mixed case, it really has 2 prongs. The underlying merits of the action taken itself, the demotion action to use our example, where the agency has the burden of proof, and then in the context of discrimination claims that the employee is asserting, we call those affirmative defenses before the board, and the employee is the one that carries the burden of proving that at the board. So it's a mixed burden of proof, and as you evaluate your options and the decision to make, it's important to keep that in mind. We love when the agency has the burden of proving that the actions taken were valid, because what we want to do is have the opportunity to challenge the agency both on the underlying action and then in conjunction to that to show why that decision is the product of unlawful sex discrimination or religious discrimination or some other form of unlawful discrimination outlawed under the Civil Rights Statute. Once you have filed your appeal with the board, as I kind of alluded to a few minutes ago, the board's first step in the process is determining whether jurisdiction exists. Once that determination is made, if it is a favorable one, then the administrative judge will, process the case and ultimately issue a decision on the merits of the case, to include deciding whether that adverse action is a product of discrimination. It's important to note that in the context of mixed cases, the board and the administrative judge also have the authority to grant compensatory damages in a mixed case. And under the EEOC's rules and the appropriate statutes, an employee bringing a claim of discrimination against a federal agency can seek anywhere up to $300,000 in compensatory damages against the agency for discriminating against them. So it's important to remember that even though you now find yourself in the context of the board, if you elect option 2, the board still does have the authority, thankfully, to issue an order of compensatory damages in the appropriate amount upon issuing a finding that's favorable on an employee's case. So with that being said, we've talked about the 2 options, option 1, which eventually leads you into option 2, which is the appeal at the board. I mentioned before that this is a complicated subject. One of the reasons it's complicated is because of the overlap and the interfacing between the board as well as the EEOC. So to give you an example of why this can become complicated because of this interaction, ultimately, once the board issues a decision, if you are in a position where you are unhappy as an employee with the board's decision, your analysis does not necessarily end there. You have the authority and the ability as an employee alleging a mixed case to now seek the intervention and the involvement of the EEOC in reviewing the board's determination as to the allegations of discrimination. So once you have a final decision by the board, what you can then do, if you're not satisfied with that context of that decision, is to appeal to the EEOC for a review of the board's handling, if you will, of the allegations of discrimination that you have asserted. And beyond that, there's also the ability for judicial review as well. So having given you a lot of information, to reiterate here just very briefly, you have 45 days from the effective date of an action to file an EEO complaint, contact an EEO counselor, and then thereafter, if a notice of right to file is issued, be sure to file your formal complaint within 15 days. And then likewise, if you're electing option 2, which is to go directly to the board, remember 30 days from the effective date of the action to appeal to the board. Be sure to be very mindful of those 2 deadlines. I touched a little bit in the course of my discussions about the subject of why mixed cases tend to be so complicated and so complex. And without sort of recapping all of that here, I'll go through a couple that I just simply haven't discussed with you yet, which deals with, how to figure out where you stand and how to move forward in trying to bring forth your claims of discrimination based on the agency's unlawful action. From the perspective of the regulation, the analysis of standing and jurisdiction is very complicated. It is. And while we've tried for our discussion here, while we've tried to boil those discussions down to general rules, unfortunately with the law, for every general rule, there usually tends to be one or more exceptions. And that certainly is the case here. So if you are someone who is trying to evaluate, A, do I have standing, and B, does the board have jurisdiction? Perhaps you've received a notice and it's not clear from your notice as to what your options are. This is certainly an area that I would suggest you consult with an attorney who can give you guidance, walk you through the situation, refer to our cheat sheets, statutes that we have, in an effort to assist you and give you dead-on advice in terms of how to advocate for yourself in this process. Going forward with the topic of why these cases tend to be so complicated, I've mentioned the interfacing of the EEOC as well as the board. So if someone is not satisfied with the board's decision, you have the right to go to the EEOC to seek a review of the board's handling of the discrimination allegation. Well, it begs the question, what happens if we end up in a situation where the EEOC does not agree with the board and we have conflicting decisions from both agencies? It can happen. So in that particular situation, there's another set of rules that kick in. In that situation, there's the ability to refer the matter to what we call a special panel. And that involves the authority of the president in appointing, through his advisors, a special panel that is designed specifically to resolve the conflict in reviewing your case that arose between the EEOC as well as the board. So the special panel can be appointed for that process. And I should also note that for a mixed case complaint, there's also the ability of, or the availability, I should say, of the judicial review process in federal district courts as opposed to federal court. And these are all distinctions that apply to mixed case complaints that do not necessarily apply in the context of non-mixed complaints that are oftentimes raised as well. So to continue on our subject, I'll point out one other area that can bring complexity into the situation. On so many instances, I meet with employees and confer with people that may not simply have a single claim against the agency. So for instance, to use our demotion as an example, Well, a demotion action usually does not happen on its own. It's usually preceded by a negative performance evaluation, the placement on a performance improvement plan, and then a determination that the employee has not successfully passed the PIP. So there may be a number of events that have transpired before you receive that ultimate adverse action that you want to appeal to the board. And if you have been diligent in proceeding and prosecuting your rights, you will have already been in a situation to initiate an EEO complaint over those prior actions, the issuance of an unfair evaluation, the placement on a performance improvement plan that might be designed to set you up for failure. So you may have already been in a process of challenging those actions. So while those EEO claims are underway, now we've moved forward and now the agency has issued a demotion action or some other adverse action that is non-appealable to the board. There are a couple of different complicated situations that arise here. And I won't give you a general rule here. This is another area where I would strongly encourage you, if you're facing this type of situation, to at least seek a consultation at a bare minimum with an attorney to explain what your claims are, to explain why you feel you've been discriminated against and what the evidence of that discrimination is, so that they can help you navigate through this process. Because again, you may be in a situation where you may not benefit from having all of the claims prosecuted together at the board. There may be reasons that we can give you that might not be the best approach for you. Or then secondly, there's also the ability to try to keep claims together at the EEOC as well. And I've provided you with some information on the slides here that talk about the board's past exercise of its review in deciding if cases or claims involve matters that are so intertwined with the claims that can be raised in appeal that the board wants to adjudicate those cases all together as part of the same appeal. And then likewise, the EEOC has taken a similar approach. And I've cited to you one of the preeminent decisions that have been decided by the EEOC that shows and suggests that under certain circumstances, the EEOC will take a similar approach in saying, well, based on the types of claims that have been asserted here and these other factors, we believe that the claims are so entrenched in the EEO process that we will elect to exercise jurisdiction over this particular claim, even though it might have been appealable to the board as well. So again, there are no general rules there. What you want to do is to consult with an attorney to find out, based on your specific claims, whether you're asserting a denial of reasonable accommodation, and now you've been, subject to some sort of adverse action, or whatever the intersection of these claims are. What we want to do is to make the smartest, best, and most appropriate decisions for you that place you in the strongest position as an employee to prevail on your claim. So I think a case-by-case approach is really appropriate in these types of situations where we're facing multiple actions or claims. So to conclude our discussion here today on the topic of mixed case complaints, during the course of today's presentation, I've alluded to on a number of different occasions the various ways that an attorney can assist you in the process. As you can see on your slides here, one of the things I've emphasized here is how an experienced attorney can help you. And I can tell you here today that the topic that we've been covering is one of the most complicated subject matters in the area of evaluating discrimination complaints and appeals to the board. So it is important to you as an employee are trying to find legal counsel to give you guidance, to help you navigate through this process, to turn to someone that has experience specifically in the field of advocating for federal employees, someone that understands these laws, understands the pros and cons. Ultimately, what you do not want is someone that simply can reiterate and regurgitate these rules back to you. But what you really want is someone that can help you analyze your case, Your case, trust me, is not like anyone else's. It's different. It's unique. There are certain factors there that separate you and separate your case from every other case. So you want to have someone on your team that can help you identify the particulars of your case, counsel you on the pros and cons of taking a particular course of action. And remember, as we've indicated here today, we've looked at two options. Both options may be valid, but one option may be better for you in your situation than the latter. So what we want to make sure, happens as you are seeking the guidance and assistance of an attorney is having someone that can help you put those rules into effect and into practice, and showing you what's the best case scenario for the specific circumstances of your individual case. Another way that attorneys can help you, of course, is in the area of negotiating with the agency to settle your dispute. Agencies oftentimes undervalue my client's claims, and they try to undervalue your claims as well. And what we want to do is to show the agency, whenever possible, how existing case law, how existing regulations, and how a whole host of factors give you a strong case and give the agency an incentive to negotiate with you on more reasonable and appropriate terms. So, certainly it's helpful to have an attorney, help you navigate the process of understanding your claims and how to bring them, as well as helping you interface with the agency. As you probably can imagine, they employ, droves of agency lawyers that give them guidance, that help them navigate this process. And if the agency has a team of lawyers working on their side, it's in my opinion, so should you. So we want to ensure that we have an experienced attorney that can help you navigate the playing field, navigate the rules, and to position yourself in a manner that leads to good results and a good outcome ultimately for you, to ensure you can advocate for yourself and to avoid injustice as you move forward in protecting your federal career. So with that being said, at this point in time, I will turn this back over to my colleague, Stephen Solano. Thank you so much for your time and attention. If you have questions about what we've presented today, again, I recognize that the subject matter is complex. We're happy to speak with you and answer questions that you have as it pertains to these issues. Thanks again for your time.
Thank you for participating in this webinar. If you'd like to learn more about how to best defend your federal career, call 1-888-529-4543 or email info@fedattorney.com to schedule your free consultation with a member of our team. As a reminder, our experienced team of national security clearance attorneys regularly assists federal employees and contractors, as well as military personnel in all stages of the security clearance process. They've helped hundreds retain their clearances. Our military law team is nationally recognized for its ability to win cases against tough odds. Our military lawyers have proven track records of changing the military law landscape through knowledge and tenacity in all matters faced by service members, including but not limited to courts-martial, discharge upgrades, and desertion. Don't leave the future of your federal career to chance. Call 1-888-529-4543 or email info@fedattorney.com to schedule your free consultation with a member of our team.